Okay.
Easy.
Hello and welcome to this Massage Magazine webinar featuring Conscious Counsel. I'm Karen Minahan, editor of Massage Magazine. Today's presenter is the founder of Conscious Counsel, Corey Sterling. Corey is a lawyer, small business owner, group fitness instructor, and yoga teacher. He wrote the Yoga Law Book and has served hundreds of clients in the health, spa, and fitness space. Corey has also presented at many conferences around the world, teaching about the law in a fun and practical way. In this webinar, Corey will offer his thoughts on best practices related to a massage practice during the COVID-19 pandemic and into the future. Welcome, Corey.
Karen, thank you for having me. So much fun.
Thank you. Thank you for being here. This is awesome for us to be able to offer this information to our audience and massage therapists.
Cool. Well, I'm here. I want, for the brief time that we're together, everyone, I want to be a source of information. I want to hear any questions or concerns that you have. The way that I always look at a webinar, it used to be that we would do this in person, but now we're obviously doing everything online. Whatever questions you might be thinking about your business, any uncertainties, any doubts, anything that you want to know about, there's a Q&A function section here on Zoom. Feel free to put in any questions. What I want to do, my goal today is to sort of demystify the law around the massage space, especially in this, this post-COVID world and how everything has changed. A lot of the feedback that we've gotten from our spa, salon, and massage professionals is that it's very confusing, it's overwhelming, there's different sets of rules in every direction, we don't know where to follow. The wonderful news that I have for you is that in a really fun and relaxed way, I'm able to talk about the major legal issues that we see all of our massage professionals going through. And I'm able to address each of these different areas, and in doing so provide hopefully like helpful and practical information that will help all of you. So Karen, if it's cool with you, I'm just gonna roll.
Yeah, that would be wonderful. Thank you.
Okay, cool. So just very, very briefly about me, although I could spend this entire time talking about myself. I'm a lawyer, I work online, and for me, it's really, really important to have a match with the type of clients that I work with. So I originally started a yoga law practice because I love practicing yoga, and I'm a yoga teacher. And it's just, I did other legal stuff, and I didn't connect with those types of clients. And I've loved the whole yoga journey. And then I was, you know, we were chatting one day with the team, and it's like, what's another service or area that we would like to work with and that all of us are passionate about? And massage naturally came about, because this is the real question. Who does not love getting a massage? Everyone loves getting a massage. I think if you're a massage professional, I hope you still are passionate and love giving massages and supporting your life in that way. But really, it's such an important therapeutic need for so many people, and it's such a rejuvenating and relaxing experience. It's like, no matter what's going on in life, if, you know, at least for me as the end user or the recipient, getting massage can, like, it changes your day, it changes everything. So I love you guys. I'm grateful for you guys. Again, the context here is providing practical information to help you as you're navigating the uncertainties of your business. And that's it. At Conscious Counsel, we practice something that's called heart-leading law. So the idea is that we're lawyers and we're real people. I understand, you know, with hundreds of clients in the health and wellness industry, I understand what sort of legal services people are looking for. And the whole idea is, I want every massage professional who's listening, I want you to focus on growing your business. I want you to focus on being able to survive and continue revenue coming in. And we're just going to basically hit you with the biggest, most important legal topics that are happening now. And that in having this information, it's like, you don't have to worry about this anymore. If we can capture all of the legal information that you need to know about in the duration of this webinar, or at least scratch the surface, then I'll be able to go to sleep tonight. And if this call goes well, and at the end of it, I'm like, yeah, Corey, you did provide some good legal information, I'll be getting a massage. So that's for me, that's my motivation today in sharing this information for you, and sharing this information with you. So the first thing that I want to talk about when it comes to legal documents, and again, anytime a question comes up, you just let me know. it's all about communicating openly and honestly. So the most important thing when we're talking about practical law is understanding that what you see on television when you see lawyers who are wearing suits and doing all of these things and blah, 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 or any horror stories you have about, you know, this person getting sued or this, that, or the other, most of your conceptions about law are quite inaccurate. And I just want to explain to you how law practically works, because when you understand how the law practically works, you can understand the things that you actually need and that you need to have in place in order to be able to operate safely, and also most importantly to operate with peace of mind. So the way that law works, and this is like a really, really important principle that if you're writing anything down, this is something that I would write down. It doesn't really matter what happens, it matters what you're able to prove. And if you get to the stage of something and anything involved in, you know, if in a litigious process, that's called evidence, but we can just call it what you can prove. And the reason why I start off by sharing this and sharing this approach to practicing law is because no one really understands how it actually works. And as a lawyer, I've been through it so many times that I just want you to know that the most important thing that you can do is have great legal documents and have those legal documents support you. So why? Why does it matter what you can prove, and why does it matter less of what happened? If something happens to two people in a room where a masseuse is providing a particular service, and something happens and neither are able to prove it, neither are able to prove it full stop, then it's ambiguous. And then there's, maybe there's a chance that it wasn't like this, or there was a chance that it was like this, or she said versus he said, or whatever it is that's going on. And I want to avoid all of that, because how you have to think about the law is there is going to be a complaint made against you. Hypothetically, I'm knocking on wood. This is actual wood right here. Okay, I'm knocking on wood. I don't want anyone to make a complaint against you. But the way the process works is someone makes a complaint against you. So they got injured through your services. You didn't do what you said you were going to do. They're alleging that there was unprofessional conduct, whatever it is that they're going to say. Okay, that's the starting point. So now a lot of people, I'll get emails or calls from clients who are like crying like, oh my God, I'm getting sued. My life is over. It's like, no, that's not really how it works. The first step is that someone will write a demand letter against you. So they're going to either do it themselves or they're going to hire a lawyer, and they're going to say, masseuse X, was really unprofessional. And as a result, I suffered all of these injuries and I can't go to work and I've got a small family and blah, 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 blah. Therefore, I need $475,000 if you don't want me to sue you. This is called a demand letter, and this is sort of where the negotiation phase really begins. Okay, thank you, Paula. Okay, cool. Anyways, the important thing, and the reason why I share this, Paula, just so you know, if you want to understand pandemic-related legal issues, and I'll conclude my point in a second, the important thing for you to understand is how the system actually works. So I'll just keep all of this related to COVID and nothing related to anything else. Someone is going to say that they got COVID from you, or through something that was being practiced, or that
Corey,
you were.
can I break in for just 1 second?
Yeah.
So I know that you've practiced and you've taught and you've been a legal expert all over the world. And I just want to make one little point that's going to help our readers or our audience right now, which is in the United States, they all refer to themselves as massage therapists.
Got it.
So I think that would be a great point to just take forward going.
Got it. Massage therapist. Fantastic.
Okay.
So
that's it. Thank you.
Thank you. That's really helpful. Okay. So the reason why it's important to understand how this process works, Paula, is that something is going to happen and someone is going to allege that you were negligent, and as a result, they got COVID-19. That's the basic line of all of these things, right? If you only want to talk specifically about COVID, what you're going to have to do is be able to show, remember, it doesn't matter what happens, it matters what you're able to prove. So this is why I'm talking about the importance of having proper legal documents. This is the work that I do with my clients and with massage therapists. The important thing to know is you're gonna want to show them, hey, before you came to work with me, I had you sign an agreement. I let you know the specific process of what we were going to be doing together specifically. You signed a waiver of liability. In that waiver of liability, I specifically alerted you to the risks and the activities that we would be doing, and you released me of any liability by agreeing to participate in the activities. As well, if you run a business, you're going to have a team that works with you, and you're going to want to have that specific information communicated to your team. So now I'm going to go through the different most important documents that you need to have. But the reason why I'm sharing this story and the reason the framing for all of this, just so you know, and because as a lawyer, I deal with demand letters of people who are alleging COVID or that they caught COVID somewhere. And as a lawyer, it's so much easier when you have the documentation in place to support you for whatever claim you're trying to defend against. Because during that initial phase of getting a demand letter, and yeah, you have to understand that if we're talking about protecting you and your business, you're going to be doing so with the appropriate documents. And that when you have the proper documentation in place, you are able to stop someone from making particular allegations or claims against you. And the best way to do that is by being able to prove and have evidence and have support that you were not negligent, that you were reasonable, that you followed the rules, and that you had documents that people signed and agreed to before participating in activities with you or while participating in activities with you. And I can tell you as a lawyer, when I respond to demand letters, having all of that information makes the problem go from something that could be massive and take all of your time and all of your attention and completely stop your life and all of your business to being like, oh, cool, it's just one email with a response of taking a screenshot of a particular part of an agreement or responding to another lawyer with a part of an agreement. And that's like, then the buck stops there. This whole problem's over. So that's the context. I just want people to understand from a lawyer's perspective how, a COVID related issue works and what needs to be done. So the first thing that I just want to say that's really important is the importance of following rules. At law, there's something called negligence, and okay, COVID, we're talking about pandemic, if that's the specific focus of this. What the easiest way for you to be at risk or to put your business at risk is by explicitly not following the rules that are either put out at a municipal or state level. Okay, why is that? The government has said, okay, if you're going to be performing these services, these are the rules and this is the framing around how you are allowed to do that. And I can tell you as a lawyer, again, I've been through the demand letter stage in so many different levels. If someone got injured or got hurt or something COVID related, and we could prove that massage therapist was not following the rules, that, the state of Massachusetts had a very specific procedure in place for where services could be offered or how they were going to be offered or whatever it is, and that massage therapist did not follow those rules, easy. That's like any lawyer would be just, rubbing their hands like that, because it's, if you are not following the basic rules of the government during this time, you are the most susceptible to a claim of negligence. And even if you have great legal documents, if you're not following the rules of the government, then you're susceptible and liable to a claim. So the first thing, practical information that I want everyone to take is go to the, either your municipal or your state government website and understand specifically what it is that you are allowed to do and what you are not allowed to do. And as best as possible, make sure to follow those particular rules. Full stop. If you want to know the starting place for this entire conversation about operating as a massage therapist in this particular climate, that is the first thing that I have to tell you to do. The second thing to do would be the importance of having an updated waiver of liability. So the story about waivers of liability and how they've changed during this pandemic are as follows. A waiver of liability is a document that someone signs where they are releasing you from legal responsibility for any activity that you are facilitating with them, that you're doing for them. At law, there's something that is called a duty of care. And a duty of care in plain English means a responsibility to take care of someone else. So if I'm a massage therapist and I'm giving you a massage, I have a legal responsibility, I have a duty of care to make sure that you're going to be safe with me and that you're not going to get injured and that I will not transmit communicable disease to the best of my ability. Why waivers of liability have changed so much in the past couple of months, there's a couple of reasons. The big concept that you need to understand about a waiver of liability is the extent that it is applicable and the extent that it will hold up during the negotiation phase. I'm not talking about court because 95% of claims will settle before it gets to court. Going to court takes a lot of time and a lot of money. And that's why I focus really on the demand stage, the demand letter stage of all of this. in a demand letter stage, if someone says, hey, you know, my client got COVID or my client got injured or this happened and you were negligent, the degree that your waiver of liability will apply and protect you matters entirely on how specifically that particular document is drafted. Specifically, what activities are listed in that document, what the risks of those activities are, what the outcomes of those risks are. Understanding those three things, so I'll repeat them again. The three things are what activities you are doing together, what the risks of those activities are, and what the outcomes of those risks are. Those are three things that have to be included specifically towards your business. After you've listed that, someone has to agree that they are healthy enough to participate based on the types of activities and the risks that you've described. They voluntarily choose to participate and they release you of liability. So the biggest issue that I saw in working with massage therapists in North America during this period was that their waivers of liability were not updated to either cover A, the specific types of services that they were doing, or in a COVID-related instance or issue, it wasn't specific about a communicable disease. From a policy level, and when we talk about policy at law, what we're talking about is why does government make law and whose interests are they looking out for? And the whole idea of a waiver of liability is that the government says, okay, well, it's pretty overreaching of you to want to take away someone's right to sue you. And the only way that we're going to actually let someone sign away those rights, if it is crystal clear about all of the risks, all of the activities, all of the outcomes of those risks. So if you don't have those pieces in place, it doesn't help and it doesn't work for you. Specifically, when it comes to COVID, why everything has changed in all of these industries is because the activities are different. Now you are providing, massage therapists now are providing a massage in an environment where there is a communicable disease, and while social distancing and wearing gloves and wearing a mask and all of these things are ubiquitous in general society, in the actual performance or services of massage therapists, it's slightly different due to the nature of the service that's being provided. So when we talk about how and why waivers of liability have changed, or why it's a really, really, really important document to have, it is because A, someone is signing away their legal rights to bring an action against you, and the government's like, okay, cool, they can do that, but it has to be very, 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 very specifically and clearly written. And B, there's now a communicable disease that is in our society, which makes everything more challenging. The question, I'm just gonna read one of the questions, Karen, if that's cool. Do the words in our liability statement need to change? So hopefully after the response that I've just given, what your waiver of liability needs to address is what activities are you providing? What are the risks of those particular activities? What are the outcomes of those particular risks? And then someone having an affirmation of health, and I'm going to talk about affirmation of health in intake forms in a second, an affirmation of health, voluntary participation, and ultimately release of liability. Okay, so that's all of the waiver of liability stuff. And like, again, from all of my practical experience with massage therapists, the waiver of liability, a well-drawn waiver of liability, is a great first front of defense. When I'm talking about negligence and following rules, this sort of relates to the intake form and what various elements are relevant for an intake form and what needs to be included post-COVID. And I think the biggest things have to be about firstly, like gathering information about someone's health, right? So let's say if we use an intake form that we used to have, which is standard and maybe it's provided by an awesome insurance company or not, you just have this traditional form that doesn't address any of the new issues or pertinent information. So it could be, you know, past medical history and injuries and where the specific injuries were and last time you had a massage and all of this information. But now in the intake form, we have to show that we're not being negligent, and we have to, our duty of care has increased, and we have to include information about, okay, you know, have you been tested for this disease? Do you know, has anyone close to you had COVID-19? Have you traveled to any areas that are specifically in more danger than not? Maybe you take someone's temperature and you write it down, all of these specific things. And again, coming back to the first point that I was trying to make, which is all for context. The reason why it's important to have an updated intake form is because in law, you are always telling a story. So if there's a complaint filed against you or there's someone filing a lawsuit against you, you're going to want to have to tell a story through your documents and through your actions. And the more specific you can be in an intake form to add specific provisions related to COVID, the better story you're able to tell about how you follow the rules, how you paid attention, how you asked all of the appropriate information, and how you use that information to make the right decision about who you work with and who you did not work with. So the intake form is something that has changed. And remember, the reason why it's changing is because we are doing everything to objectively show that we are responsible practitioners. And for a modified intake form, you don't need a lawyer. You don't need a lawyer to do it. It's something that you can do yourself, and it can sort of just be common sense, showing you took someone's temperature, showing that you asked the relevant questions if they've had the disease or not, showing that you asked if any family members did or if they've been to an area that's particularly more susceptible to this disease than other places. So I hope that makes sense, and I hope this whole narrative as well about storytelling is also relevant. The next thing that I want to talk about are contractor and employment agreements. This is an area that we've had a lot of work in, just because the rules have changed. The way that we teach law at Conscious Counsel, all of it has to do with communicating openly and honestly in the relationships that you have. But because the activities of what we're doing have changed, our relationships have changed, and as such, we need relevant documents that are COVID related, that address all of these things. So the biggest issue, there's a couple issues when we talk about contractor and employee agreements at this particular time. I see there's a question. I'm going to get to your question in just 1 second. Okay, so the biggest issue is, let's say you operate a studio and you have a variety of massage therapists, okay? And they're employees. When you have employees, you are able to control the services that they're providing. You're able to control it, full stop, that's it. And as a result, because there's so many issues of negligence and safety and following the appropriate rules that's provided by either municipal or state government, as a business owner, we're not in the room all the time with all of our massage therapists. So we don't always know exactly what's going on in there. But what we do want to know is that we can prove that we clearly communicated the procedures that we have, and we clearly communicated the safety precautions that we have taken. Why does this matter? Let's say there's a hypothetical situation where a client receives a bad massage or someone gets COVID from our particular place of business. What we're going to want to show as a business owner, again, to combat negligence, because the biggest claim in COVID is negligence, showing that, hey, you didn't take the proper precautions that you were supposed to, and as such, we got COVID and we suffered and all the terrible things. So when you have employees, you have more control over the way the services are provided, and you can literally script the type of safety precautions that need to be taken, how services are performed, and how services are performed are usually included. But just being so specific that if a claim is made against you, if it's made against the massage therapist themselves and against the business owner, as the business owner, you want to get all of your ducks in a row and be able to show, well, actually, we instructed this massage therapist to do A, B, and C, and these are our protocols, and here is a recording of the Zoom meeting that we had with all of our team when we explained to them what needed to be followed and how the rules needed to be followed. So the biggest issue is about control and making sure that there's that documentation. As a lawyer, when you're looking for evidence, remember, it doesn't matter what happens, it matters what you're able to prove happened. And documents are the greatest, for me, it's like the greatest relief when I'm speaking with a client. I'm like, okay, can you show me that there was an agreement? Can you show me what was signed? And they have something that's really awesome and perfect. The other issues related to having employees is one is including a voluntary return to work. We saw a lot of issues coming up with massage therapists who maybe felt pressured to be coming back to work. And you know, if you run a business, you want to have all of your employees sign that they're voluntarily returning, and as well an indemnity provision, which basically means that the massage therapist assumes their own responsibility to make sure that they're following all of the rules. Another thing that we've seen is before with employees, business owners would be, I don't want to say generous, but they were fairly confident that they would have enough clients coming through that they could guarantee a certain number of hours of work. And what we've seen from the business owners is a change where they're trying to get more flexibility to say to some of their massage therapists who are employees, hey, like, we're really trying our best to get you as many clients as we can possibly get you, but we can't promise that. And as such, you know, we've modified our working relationship to reflect that. And remember, two parties can agree to anything that's not illegal. And the point of modifying these agreements is, as the business owner, making sure that you're doing what's most important for you and your business so that you can keep your doors open. On the and I see there's a couple questions coming in, which I want to get to, and I just want to touch this point. On the contractor level, the tricky thing is that at law, in the United States and in Canada, you're not allowed to control the services that a contractor is doing. So you can't tell them how to do their job. They shouldn't be wearing a uniform from your business. They should be using all of their materials. And the way that you want to think of a contractor is someone who operates their own business but happens to be providing a service for you. The challenge that we've seen has been that business owners are trying to control their massage therapists who are contractors, which inherently you can see the conflict there, that like the essence of the business is that a contractor runs their own business. And now finally, you know, we have the business owner who's trying to be more hands-on and implement procedures and rules that be followed. So the point of having a revised contractor agreement is putting in provisions, for example, that say, you will follow best health practices when doing, when providing your services. We're not going to tell you exactly what to do and how to do it, but you have to make sure that you're following the particular rules. And again, just being super, super clear and having all of that supported in writing. So I'm just going to address some of a question that came in. The massage therapist should consider all these concerns, or the workplace has the responsibility to have the consent of the client in terms of being sure that the therapist is healthy and doing her job correctly. I think to answer that question, so generally my understanding of that question is, whose responsibility is it to make sure that maybe the space is safe and the clients are safe, right? We have to think about, as a contractor employee, we don't want to be at risk either. So who's responsible for ensuring all of the safety? Firstly, I would hope that any massage therapist feels comfortable in the place where they're working, and that if they're not the business owner, that the business owner has shown to them, again, legal documents and procedures, has shown to them that safety precautions have been taken and that no one is being put at risk as a result of the procedures that are in place. One of the distinctions that comes up at law has to do with something that's called vicarious liability. And that means in vicarious liability, an employer, so your boss, if you're an employee, the employer is responsible for the actions of the employee. And as such, if you're an employee, I think that you could be more rest assured that your boss would ensure that you have a safe environment and that everything is taken care of, because again, you are at the service of your employer. As opposed to if you're an independent contractor, I would see more of the responsibility falling on your shoulders as a massage therapist, as a contractor, because you run your own business and you just happen to be providing a service, which is one part of the bigger service for whoever's hiring you. So that's my best answer. I try to keep things as non-legal as possible, but basically when understanding who's responsible, the first thing you want to think about is A, am I employer or employee? And then two, as such, if I'm a contractor and I run my own business, I need to cover my own butt and make sure that I'm protected in doing so, because an employee would likely be covered by an employer. But the general tip, and like this is for everything that we talk about in law and relationships, communicate, make sure, you know, get the assurance from whoever you're working with, you know, that you as a massage therapist, that these procedures are in place, that whoever you're working for has taken all of the necessary precautions so that you can safely return to work.
Hey, Corey, we've had a couple people ask if there's a way for someone to actually prove that they contracted COVID-19 from a specific massage practice. Is there?
No, it's very, very difficult. I'm not I'm not an expert on communicable diseases, but I could foresee a situation where someone would claim as such, and it would be coincidental, and at law, it would be a challenging question of fact to be able to prove that yes, you specifically got it from one particular person or one place. But again, and this is like the reason, I hope that I'm drilling this one point into your mind. You want it, if in the event that someone is claiming that even a claim, there are bogus claims made everywhere, all over the world, even before COVID-19, and there will be after COVID-19. But if someone is making a claim that they contracted a communicable disease from receiving a massage from you, they're gonna hire a lawyer. That lawyer's gonna send you a demand letter. Like everything I spoke about, all of those things are going to happen. So what I'm preparing my client, I practice practical law. I only care about on a day-to-day basis what people need. To answer the question, it's not the easiest thing to prove, but a good lawyer can make a great argument for it, because that's what lawyers do. Lawyers come up with arguments to try to get money for their clients. And I want all of my clients to avoid that situation by being able to tell a story of like, okay, no, you didn't contract it from receiving it from, you know, a massage therapist who works with us, or, you know, from a massage therapist who worked with you. And in addition to that, these are all of the precautions that we took. These are all of the procedures we had in place. This is how we instructed our staff. And like all of those points added up make it much, 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 much more difficult for someone to be able to succeed in a claim. And just think about it, like everyone, think about it, whoever's listening, think about it like this. Think about it if you had no documents in place and you didn't have any support or information to show that you were not negligent, and you get that letter saying, hey, person X is claiming that they got COVID from your place of work or from this massage therapist, versus having all the documents in place. And like, that's the point. We've hacked law to just get you all of the information that you need to protect yourself, because practically this is how it unfolds. So I hope that
are there any statistics coming out, or any figures that you have information about like the number of clients who might be bringing cases against massage therapists?
No, I don't have that information. And again, Karen, the tricky part is public information is provided by the courts, like obviously through transparency, so justice can be seen, but that only happens when it gets to the level of a claim being filed, two parties actually entering court. And because courts are so backlogged and this whole process takes so long, we don't have that public information. Settlements are always private, and any settlement agreement will have a confidentiality provision that says, okay, blah, 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 $12,000, you get a check for $12,000. You will never talk to anyone about this. You cannot disclose any information about the settlement. So unfortunately, that information's not privy to the public until it gets to a big case. And once there's a big case, I mean, that won't even speak to the volume, because again, more than 90% of all suits settle out of court, and that's private information.
And can I just clarify that the intake form and the waiver that you talked about previously, that would apply to anyone who's an independent self-employed massage therapist, as well as someone who is an employer of employees or independent contractors, correct?
Yeah. So if let's say you're a massage therapist and you have you're not an independent contractor, but you run your own business, you're a sole practitioner. You're going to want to have these documents in place, because you want to tell the story about all the precautions that you took and how you weren't negligent and how you followed the rules. If you run a business and you have massage therapists who work for you either as contractors or as employees, you're also going to want to have those documents, because for the same reason, it's like you have to tell the story. You have to show that objectively that you took the necessary precautions and you thought about all of the relevant issues that were coming up. Does that help?
It does. Thanks. Yeah.
Were there any other questions?
You know, there's one that came in. A couple of people are just wondering, you know, in their intake form or their intake interview, how much can they ask clients, for example, like if they've been traveling out of the country or if they've been to any large gatherings, that kind of thing, where they might have, you know, been in danger of contracting COVID-19?
I think there's relevant. The question is, if someone has been to a large gathering and they're unsure of their health.
Well, it's like how much can the massage therapist ask the client or potential client about their life and where they've been and what they've been doing?
I would be okay. So everything at law that we practice is about communicating openly and honestly in relationships. And I think so long as the context and the framing for asking these questions is, you know, like if you can show that there's a very, very specific, a very, very specific purpose for why you're asking it. I think someone could refuse a question. Someone could refuse, you know, on human rights grounds, they could refuse to answer a particular question or provide information. But I think if you're saying, hey, like I'm asking you this information because we need to know that you're healthy enough before we allow you into our environment, I believe that works. So I hope that helps. And it's like, that's the whole point of all of this. It's just to have better relationships with the people that we work with. And again, like the other thing that I've seen from working with so many clients in this industry and in the health and wellness industry, the better relationships you have with the people you work with, the more problems you're going to avoid. And we use documents as a tool for that. I want to speak to something that Dirk had mentioned, which is, Dirk is correct. So Dirk basically said there's a way to have procedures and uniforms with independent contractors. And you are correct, Dirk. What I was referring to, I'm talking about the degree of service of control that you have. So uniforms and invoicing and equipment are one example. Those are individual examples. But when the IRS is making a determination about a contractor or an employee, assuming that you're in the situation of being audited or complaint is being made to a labor board or bureau against you, they'll always look at the totality of the situation. So for example, you could ask someone to use a uniform, and if every other aspect of the business shows that you have a lesser degree of control, then that person could be deemed a contractor. Those are just the typical examples of things that we speak about. Okay, so and then I'm going to address this. It's not really COVID related, but there's a question from Julie that says, I have a question with the increase of sexual assault. What precautions can we take as a massage therapist? And my answer to that, the precautions that you can take are as much transparency as possible. The precautions that you could take is where relevant, as clear client screening as possible. If most of the situations where I've worked with massage therapists in these sorts of claims, there usually were red flags that came up with a particular client beforehand. So if you don't feel comfortable in a particular relationship, the sooner, you know, if you want to cease working with that particular client, usually that's a great, that's like a proactive approach to it. If something's off, you don't feel comfortable, you think, you know, this, that, or the other, then that's really important to have. I think something that's really, really important to have as well is if you are a business owner, or even if you just have a service agreement with your clients, to include a particular provision about, you know, if you have any questions or concerns, this is the procedure of how we deal. You know, we take sexual assault claims very seriously. It doesn't have to be worded exactly like that. But again, it's all about transparency and showing that, you know, this person was reasonable, took the necessary precautions, communicated beforehand. And so long as all of those, at the end of the day, if there's a sexual assault claim about something that happened in the room between massage therapist and client, you're going to want to tell the best story that you can possibly tell. And that can be that, you know, this is how the services are provided transparently. Even an example, something else that you can include in a service agreement would be, you know, consent to touch, or, you know, communicating if you're uncomfortable with something. If you have a written agreement that says, you know, the obligation is on the client, if they don't feel comfortable in a particular position or in some way, please let us know that. That can be in the intake form or in the service agreement. But again, at law, you always want to be telling a story about how proactive you were, how considerate you were, how conscious you were, and how you did everything to make whoever you're working with as comfortable as possible.
And Corey, we had another question come in from a couple of people wondering if there are any special considerations regarding practicing outdoors.
Okay, so yeah, when it comes to practicing outside, and I'm happy Isabel had asked me to go through the waiver of liability overview, so I'll just apply that. The biggest issue that it applies to, so long as the client is comfortable working with a massage therapist outside, one consideration that like wouldn't be included in a waiver of liability would be, okay, confidentiality, making sure the space is safe and that no one's able to see and that the client feels comfortable in that particular area. But remember, so Isabel, this is for you wherever you are in the world. The elements of a waiver of liability are the activities taking place, the particular risks of those activities, what are the outcomes of those potential risks, an affirmation of health, voluntary participation in the activity, understanding everything. And once those 5 are done, it's going to be a release of liability. So the reason why practicing outside is different is because the activities are different. And so when the activities are different, let's say something unforeseeable happens with, one of our clients, a massage therapist is working outside, and something happens to one of the clients outside that like we didn't really foresee or predict happening, but it happens as a result of being outside. If that waiver of liability does not specifically address or mention anything about practicing outside, the waiver of liability could easily be challenged. Why? Because the waiver of liability did not specifically address what the activity, it didn't appropriately address the activities, the risks, and the outcomes of the risks. And anytime that I've been in negotiations with another lawyer and it's about a waiver of liability, it always has to do with those 3 points. Affirmation of health, straightforward, include COVID, you're covered. Voluntary participation, it's never going to be a debate. And so long as the release of the waiver part is properly drafted, there's no issue. So I hope that that answers the question. And what you want to do is, if you're practicing outside, make sure that the document is specific towards what those activities are. Like an example of something that comes to mind, maybe there's a hot oil that it's windy and then it gets spilt over and you wouldn't have seen that before, right? Whatever. I hate thinking about these things, but it's sort of my job to think about these things. But that's an example where someone would like have a claim, whereas normally if you're inside, the hot oil's in like, that little warmer thing, right? These are very technical terms that we're using. So it's in the warmer thing and it's over there and there's no wind, so there's no issues. I hope that helps.
I think it should, definitely.
Cool.
And so we have another question from Kelly in our audience. She's asking, as a self-employed massage therapist, it sounds like I need a written policy of my cleaning methods and I need to document each time I clean. Is that correct?
Okay. We'll take it big picture and we'll be less specific about cleaning, but cleaning is part of it. So what you want to do is you want to be able to document and be able to show to someone that you have taken the necessary precautions in order to keep them safe. So that's like the big picture. Specifically, do you have to document exactly how you clean and how things are done? Not necessarily, but it is helpful to have that information to say, oh, curious about the linens that we're using or the pillows that we're using, or, if we're using gloves and how, oh, did you know that we change our gloves and we sterilize all of the equipment in between sessions? And as a massage therapist, we take this very seriously. So obviously cleaning is a big part of this, and using disinfectants and what products you use, but I would say do so in a way that, firstly, you're not focusing all of your energy and time on it, because in all of the clients that I work with, the key during these uncertain times have been keep revenue coming in. So focusing on your business and continuing to be able to serve clients, but also for the relevant issues to make sure that it is documented. And there's no perfect answer to that question, but just basically do enough to make sure that someone could not show that you were negligent. I hope that's helpful.
Thank you.
Cool. Anything else, Karen, or should I keep partying?
So there's another question that came in. Do we have the time and the space for me to ask you a couple more that have come in from our audience?
Yeah, I'm here. I have at least 15 minutes. So I want, again, the point of all of this is to make sure that everyone has the opportunity to ask questions.
So audience member Karen says that a lot of the standard legal language that is suggested that people put into intake forms invokes fear when the goal of her business is to promote relaxation. And she's wondering if there's any sort of alternate, gentler language that she could use in legal forms, or if there are very specific legal terms that have to be in there.
Thankfully, there are no specific legal terms. Firstly, you guys like that the sun is setting on me. I hope that's okay. I hope it's not too distracting.
It looks good.
Okay, cool. Okay, so no, the answer is that there's not when it comes to of all of these documents, the waiver of liability, you need to hit those technical elements that I've addressed. But for example, for a release of liability, that's like the most part that has to be most legal-y. But at Conscious Counsel, we draft all of our agreements in plain English. So the rule is if a 7-year-old cannot understand it, it doesn't go into one of our documents. And the point of that is we want our clients to be confident and to use their own brand and voice when they're using this. So for example, for a release of liability, when you're talking about the activities, when you're talking about the risks, all of that stuff can be in your language. But when it comes to the actual release of liability, you're going to want that to be documented, and just making sure that specifically you have particular things covered, like particular language covered. And that would be like, it's you, your heirs. Well, I mean, I could go on forever being specific, but long story short, use your own voice. And the point of what we try to do when we make documents is help our clients set the tone. The legal agreement, the waiver, the intake form, it's the first agreement that it's people's first interaction with your business. So if it's daunting and fear-inducing and all of that, yeah, I could see how that would be off-putting. And the important thing is to use your own voice. And no, legalese is archaic, it's awful, it's confusing. You can write your own, you can totally write your own agreements. The thing about working with a lawyer is a lawyer A knows what elements they are and are trained in this specific field, and B, they know what all of the pain points are for the most part, so they're able to draft it accordingly. But I'm with you, and even for our clients, just one final point. One of the questions that we always come up with is do we include death as being an outcome of the activities and the risks? And some clients will say, no way, I don't want to include that. And some clients will say, well, someone could have a heart attack during a massage, so I want death to be included. And it's just it's a personal preference and a choice for the individual.
So I just want to make a comment because a lot of people have asked. We do have a sample intake form that was created by Conscious Counsel. We also have an ebook by Conscious Counsel, and you can get both of those on massageliabilityinsuranceGroup.com. And if anyone would like to send an email to edit@massagemag.com, I'll send you a hyperlink directly to those items.
Fantastic. Yes, we've prepared resources because we want to help. And again, love the questions. I feel a bit robotic during this time of just answering all the questions, but I'm having a great time. There's a question from Mo that I wanted to answer, if that's cool. Does one need to inform the client the pros and cons of receiving a massage in a room within a room? And I think what all of this, and the issue being poor ventilation, and the reason why I like this question is that it always comes to communicating expectations openly and honestly, and also fairly letting people become aware of the risks of a particular activity that they're doing with you. And so long as you do that, for example, Mo, let's say there's a room within a room and there's poor ventilation. If you find a way to, creatively and kindly share that information with your clients and say, hey, due to our place of practice is a room. Even conceptually, I'm thinking of a room within a room, and I can't really see it. But anyways, so long as you communicate openly and honestly and you let people know what they can expect from working with you beforehand, like, you're good. Someone wouldn't be able to come back afterwards and say, oh, well, you never mentioned A, B, or C, or this, that, or the other, whatever it is. Like, just what I teach people law is, like, be a real person. Just tell people what they can expect from the relationship. If it has to do with a waiver, what the risks are, where you're providing the services. If it has to do with a contractor agreement, what the expectations are and how much control you have and where you control things and where you don't control things. And if it's an employment agreement, making sure voluntary return to work, all of these things are just tools, using the law as a tool to communicate openly and honestly. And, like, yes, from the first question that came in, you want me to talk about COVID. Sure, COVID is an aspect of how all of our relationships have changed and how our legal documents have changed. But the principle, the overarching principles are still the same. And that is communicate openly and honestly. If someone assumes that risks, they do so from their own volition.
And let me just jump in real quickly. We've had a few people say that I spoke a little too quickly when I was giving that link for the intake form. So I'm about to say it again. It is massageliabilityinsuranceGroup.com. And we have the Conscious Counsel ebook and intake form there.
Cool. And and I'll just give anyone any more opportunities to ask any questions. But just in summary, what I want to say, like, I think I've had enough fun doing this that I feel comfortable getting a massage this afternoon. And so I hope that the information I provided has been helpful to you. But what I'm trying to share, I'm trying to demystify the way that everyone looks at the law, and that in COVID things are more uncertain, but as much as things are uncertain, it's a great indication to us that the most important thing that we have to do is be able to tell a story with our documents. You want to be able to tell a story that you were a proactive person, that you were responsible, that you considered the important issues before they arose. And the more that you can do that, the better. If we've learned anything during this period for massage therapists, everyone is human beings. There's no certainty in life. You can wake up one morning and your life can be completely different as it was before. From my experiences of working in law, the best thing that you can do is be prepared. Have documents that if there's an objective third party or another lawyer who's going to be reviewing the situation, give them every reason to show that you did everything that you possibly could have to be prepared for this. And do so with love. Don't be scared of the law. Embrace it. Look at it as an opportunity to communicate in all of your relationships. We're going to include a link in the chat as well. Last week we were totally booked. We weren't taking on new clients, but we do have a special package of documents, which includes a privacy policy, a waiver, and a service agreement, and then either a contract or an employee agreement. We only have five packages available, just because things are happening so quick. There's a special discount code, and we'll include that in, we'll include that in the checkout, and you can write me an email. I'll type my message into my email in the box.
I'll just add that everyone on this webinar will also receive an email that has a link to the intake form that I mentioned earlier. So we'll make that easier for you.
Okay, cool. Like, what a pleasure. Thank you Karen. Thank you for the opportunity. I hope that everyone looks at the law in a more positive way. And I think from all of this, I'll just choose my highlight was the question about, seeing these documents as being scary and putting off to clients. And I want to remind everyone, law is about empowerment. It's about communication. It's about creating the perfect relationship with all the people that you work with. So keep that in mind. We're an email away. And keep providing amazing massages to people. You're making the world a better place.
Thank you so much for being here, Corey. We really appreciate your expertise from Conscious Counsel and look forward to continuing to create great products with you in the future. Thank you. Thank you, everyone.